It's my pleasure to introduce our final panel, Marijuana and Criminal Justice Reform, the last panel of the conference. And it's only fit that we end with criminal justice reform, where the conference began. Dean Onwuachi-Willig began by noting that we are at perhaps a tipping point in terms of the decriminalization and legalization by states, and the new questions that have arisen about how to address the legacy and harms of past criminalization. We've heard throughout the conference about various aspects of a pathway to criminal justice reform in this area, but we're delighted to be able to pull together those threads at the end with a final panel that will take on these questions head on, addressing remedies, post-conviction relief, the role of the age of majority and children, and how to address policing in a new age. So I'm going to start by briefly introducing our talented panelists. Each panelist is going to take about 15 to 20 minutes, and then we will invite Q&A. So feel free to be clicking and writing your questions into the Q&A boxes, which we'll address at the end. With that, it's my pleasure to introduce our panelists, and this is the order in which we'll move for today. First, we have Professor Douglas Berman, the Newton D. Baker and Hostetler Chair in Law at The Ohio State University Moritz College of Law. Professor Berman teaches and writes in the area of marijuana law. He also, as many of you know, runs the Marijuana Law and Policy blog, where he's written extensively about a host of emerging questions related to marijuana law, including most recently, how might partisan perspectives on marijuana law evolve as we enter the new political era? In what states and how quickly might we now see marijuana reform through the traditional legislative process? And in recent years, Professor Berman has appeared on national television and radio news programs and has been extensively quoted in various outlets. We also have Kate Silba, the professor of law at Boston University. Professor Silba is widely recognized for her pioneering work on sex, gender, family care, and also household labor, including but not limited to a collaboration with Judge Posner of the Seventh Circuit, for whom she clerked, to survey America's sex laws, and also the co-author of the Essentials of Family Law with Catherine Baker. As of late, she's explored how the age of majority intersects with diverse issues such as voting, concussion risk, and now marijuana. And she's going to offer her thoughts about medical marijuana and the age of majority. She will be followed by Julie Steiner, the professor of law and director of the Institute of Legislative and Governmental Affairs at Western New England University School of Law. Ms. Steiner, Professor Steiner, is a BU alumna and also teaches cannabis law and policy, and her scholarly work focuses on legal policy reform and enforcement theory. And more recently, she's turned to the historical development of and also normative approaches to cannabis law and policy. She also has played a role on the ground in responses to marijuana policy, as she assisted the city of Springfield, Massachusetts, in developing a process to solicit and select marijuana shops. And she's going to discuss the important issue of post-conviction relief in her presentation, Cannabis Record Sealing and Expungement, Legality and Best Practices. And finally, we have Tamar Todd, who's the legal director to the New Approach PAC and lecturer at UC Berkeley and UC Davis. Tamar Todd is an experienced attorney with expertise in a broad range of areas: policy advocacy, legislative drafting, statewide campaign strategy, and nonprofit management in the areas of drug law reform, cannabis law policy, public health, and criminal justice. She's the former legal director of the Drug Policy Alliance and has particular expertise in marijuana decriminalization, legalization, and regulation. She's co-authored several state and local ballot initiatives and statutes, including Amendment 64 in Colorado and Proposition 64 in California. And she is going to be talking about the intersection of policing, criminal justice reform, and marijuana law reform. So with that, please welcome our panelists, and I'm going to turn it over to Professor Berman to begin.
Thank you so much, Julie, and thanks to all my co-panelists. Extra special thanks to Jay Wexler and everybody involved with putting this event together. It's obviously not under the circumstances we all would prefer. I'm especially sad not to be able to travel up to Boston, where I've got a daughter going to college, and it's one of my all-time favorite cities. But hopefully we can do this again and do it in person when times permit. But until then, I've got, if I can get my screen shared properly here, a little set of topics that are among my favorite that I'm excited to have some time to talk about. And so that's playing, I'm assuming, start from beginning. There we go, everybody can see that. Not hearing otherwise and making sure I stay on time, I'll get started. For me, this topic, is sort of where we start, because I very strongly believe that it's the harms of marijuana prohibition, broader concerns about the harms of the war on drugs that have been propelling reforms. There are other forces. This whole symposium has been spectacular, highlighting all the different issues that intersect with marijuana reform and policy. But for me, it's not just the existence of the harms of the war on drugs, but our desire to redress them. And the core question I have, and I think we'll continue to struggle with, is, are we redressing those harms through reform, and how do we know? And of course, to start here with a quote from the press release by Senator Cory Booker. There's a little hint to where I'm going in the background of the picture, by the way. But he introduced really the first big federal proposal for marijuana reform, the Marijuana Justice Act. And he emphasized in this context that, it's coming on the back of decades of what he called unfair, unjust, failed policy. And he also stressed that repairing the damage caused by the war on drugs was the ultimate goal, that this reform energy is not just about legalizing the use of one plant, it's about justice. And so with that frame in mind, we think about, and I actually start thinking about the fact that roughly 50 years ago, we were at an inflection point, understanding the harms of criminalization, apart from what we might think are the harms or the risk of harm from use of a drug like marijuana. I think in the history panel, there was some discussion of the Schaefer Commission report. I always go back to emphasizing it because it's not only a spectacular report that's as sort of lively today as when it was put together roughly half a century ago, but they particularly added this sort of really important nuance, which was, even if we don't think using marijuana is appropriate, even if we as a society want to discourage its use, we need to be attentive to the reality that doing so through criminal law is a dangerous and problematic way. Their language was, criminal law is too harsh a tool. And among the reasons I like to emphasize this is, wherever we end up with marijuana policy, the same may be said, I'm generally convinced it should be said, for all drugs, right? Even if we don't want people using drugs, even if we think as a society we should be discouraging drug use in a variety of settings for a variety of reasons, keeping in mind the harshness of using the criminal justice system, that it is a tool that just isn't justified or needs to be reach, in my view, a very high level of justification. And this is a broader problem that many people concerned about mass incarceration and our criminal justice system at large, addresses how we've turned to criminal law first rather than last. But it's kind of valuable to go back and remember 50 years ago, we had some experts saying we've got that backwards and we ought not use the criminal law. But of course, that's not what we've had. And in fact, you look at how much damage we've actually created, harsh damage, as I'd call it, using language from both the Schaefer Commission and Senator Booker. But for me, the front word here is unmeasured, because we only have a very limited understanding of just what we've inflicted through the war on marijuana, through marijuana prohibition. Thanks to the FBI, we have some good but not really great data, and I call it ugly data, on marijuana arrests, and I could go through that at great length. But sort of in short form, this is part of a broader reality of drugs being kind of the most arrested offense. Over 1.5 million people arrested for a drug offense in 2019. 85% of those were for possession. Looking at the marijuana patterns in particular, they peaked in the late 2000s, 20 aughts, I guess you call it, at around 850,000 arrests per year. Thanks, I think, in large part to modern reforms, we've seen that decline. The last few years, 2019, we had only, and you see I have only in quotes there, 545,000 marijuana arrests. Just to put those in some terms, these numbers wash over us. That means today, assuming this is an average day, we're going to have 1,500 people arrested for marijuana in our country, despite all this talk about, how the nation is moving away from the war on drugs, all this talk about marijuana reform being such a big winner in the election just passed. That's 10,000 people this week alone. Nearly 50,000 people this month. Although I put a little parenthetical in there, I'm very interested, and I don't know where we can get this data because it takes a year plus for the FBI to collect data from around the country. Whether we're going to see that number drop a lot more in the COVID era, I certainly hope so. Talk about something that seems unjustified to actually create contact and potentially a time in jail for marijuana possession these days. 90% of the arrests historically, more than that, have been for possession in all of these settings. But it's just to realize how robust this arrest machine still is for marijuana and how critical it is to understand that when people say the war on drugs is over, or let's not go back to the war on drugs. We never got away from the war on drugs. And in the marijuana setting, the intensity and the massiveness of the arrests and the criminal justice context that this creates. Now, it's important to keep in mind, most marijuana arrests don't result in a conviction. Most marijuana convictions don't result in incarceration, but some do, and I'll get to that in a minute, but we really don't know how many. That's the unmeasured piece of this, and that's kind of where sort of I'm going to be writing a little bit more, I think, for the symposium paper here. We have little data, certainly almost no nationwide data, on how many of these marijuana arrests actually lead to a prosecution. We have precious little data on how many of these prosecutions actually lead to convictions. We have precious little data about how many of these arrests and convictions lead to incarceration. And of course, an arrest alone can get you put in jail under certain circumstances. A conviction can get you also put in jail or maybe incarcerated in prison under certain circumstances. We have precious little data on alternative dispositions, fines, other forms of lesser sanctions that still can be an incredible burden on a variety of individuals in a variety of settings, or diversions. You know, a big story of the history of marijuana treatment was that most people were choosing to go into treatment because it was a way to avoid potential criminal justice sanctions. And we don't have really good data on that either. We also lack good data on the role of marijuana in supervised revocation. You know, people on parole, probation, other forms of community supervision. A dirty urine being found with marijuana can be enough to get you remanded or just have additional sanctions imposed. All of that is still very opaque. Hard to get data on this in a single jurisdiction, let alone nationwide. And then probably the biggest story here is the connection between marijuana enforcement and other forms of criminal justice entanglement. The way in which, you know, an officer saying they smell marijuana leads them into a car, into a home, into somebody's life, and then that then produces further entanglement with the criminal justice system. All of that needs more unpacking, needs more understanding before we can fully take stock on the damage that has been done for all these years. We do know one thing, though, and the ACLU should get considerable credit for highlighting this in a series of reports. We know that the data we have shows extraordinarily depressing racial disparities, right? In 2010, based on that data, the ACLU reported in a big 2013 report that across the nation, blacks are almost 4 times more likely than whites to be arrested for marijuana possession. They did a follow-up to that report a few months ago that was terrific in highlighting that arrest rates are going down across in various jurisdictions thanks to modern reforms, but we're still seeing these racial disparities, and in fact, they're increasing in many jurisdictions. That's actually something that those of us who work on other criminal justice disparities actually know and often get depressed by. The more we shrink the overall footprint of the criminal justice system, often we exacerbate disparities. The privileged tend to be the one that get more breaks as the system shrinks, and so it's not surprising we see the ACLU reporting that in 31 states were larger in 2018 arrest rates than in 2010. And I think there's every reason to fear that these disparities only worsen as we move through the stages of the criminal justice system, from arrest to prosecution, from prosecution to conviction, from conviction to sentencing. The evidence shows in other settings that you don't work against latent systemic disparities. Those usually get worse. And so those are, again, the data that, you know, what we know should be discouraging, and there's every reason to think we have a lot more work to do on that front. Mentioned, I think, in a variety of panels earlier, and just important to sort of highlight all the different ways in which convictions in this space, even just arrests, can carry profound formal and informal collateral consequences. There's a really good U.S. Government Accounting Office report about the collateral consequences of just nonviolent drug convictions. They found 641, and 500 of those nearly are lifetime collateral consequences, so they don't go away when you finish your sentence or otherwise gotten disentangled from the criminal justice system. And of course, the formal sanctions are only the tip of the iceberg. State laws, private actors, our economic system imposes an extraordinary array of formal and informal collateral consequences for those, even with just an arrest record, all of which are, of course, more easy to find in our digital world. And so, it's a discouraging story. An important point also to keep in mind, and I think it's part of being balanced and sensible as we think about these issues. Folks who are concerned, particularly about mass incarceration, rightly say that marijuana reform can't fix mass incarceration. That's a headline from a Vox piece months ago, which I think is absolutely right. Important to keep in mind that depending on how you measure it, total incarceration for drug offenses is probably less than 20% of our entire sort of carceral footprint at any time. Total marijuana incarceration is probably significantly less than 5%. But here's an important point about mass incarceration. Even a small slice of mass incarceration is massive. The Last Prisoner Project, which is a new advocacy group that I highly recommend because they're focusing on doing work specifically looking at the incarceration population. They assert, based on some interesting efforts to tease out these numbers, that there are over 40,000 cannabis prisoners in the U.S. Just to give you a sense of that, that's more than the entire prison population of Canada. If you don't want to think about cold Canada right now, we can shift to warm Australia. That's about what Australia's prison population in total is. And so, when we say we're not going to fix mass incarceration, that's true. It's just a small piece of the mass footprint, the mass carceral state we've built here in the United States. But if we could get 40,000 people out, that does something. What I do think is important, I can tell a little sort of war story here from one of the cases I've worked on. Even how we define who's a cannabis prisoner, who is in for marijuana offenses, is necessarily fraught and complicated. Some people might have remember the name Weldon Angelos. Wonderfully, he's been released in recent years, but this was the fellow who sort of became the poster child for excessive federal mandatory minimums, because as a result of 3 relatively small hand-to-hand marijuana sales, he got a 55-year and a day sentence. Now, here's the complicating point. The reason he was subject to such an extreme sentence for marijuana sales is he had a gun with him. Didn't use the gun. Debate about whether he even you could see the gun was in his possession when he was doing these sales to a confidential informant. But the way federal law worked at the time, each incident that included a gun led to an additional chunk of federal time. And so technically, his marijuana sentence was 1 day, but he got 55 years for his gun possession in conjunction with his marijuana dealing. And so, that's, to me, a cannabis prisoner, and most people thought of the case that way. But when you combine whether it's being involved with marijuana offenses and other drugs, whether you combine it with guns or other, associated criminal activity, I actually think it's probably larger than 40,000 individuals incarcerated for marijuana-related activities. But ultimately, whether it's 40,000, even if it's less, I think getting those folks out should be a big part of what marijuana reform is trying to achieve, above and apart from whether that's enough to fix mass incarceration. I do like to highlight one other point here that is telling and significant as you sort of look at the criminal justice footprint. We've seen an incredibly dramatic decrease in federal marijuana trafficking prosecutions over the modern marijuana reform era. Got a little data there in the 3 years kind of before Washington and Colorado came online. There were, roughly speaking, close to 7,000 persons being sentenced in federal courts for marijuana trafficking. That's dropped to a yearly average of about 2,000, a little less than that even this last year, and lower sentences. My understanding is that's largely because there's not nearly as much marijuana being brought up from Mexico. The federal government sort of views itself as, looking at large-scale trafficking, particularly from other nations. And so, that alone, may be overcome by other kinds of prosecutions and other things that are going on. But if you just kind of run the numbers there, we're looking at, roughly speaking, 25,000 maybe years of incarceration saved because the federal government is not as focused on those sets of issues. Other ways, looking at criminal history enhancements, as many of you may know, if you have any criminal history, particularly drug criminal history, that can often increase your sentence under federal law, under state laws. Those are things that we could and should be thinking about unwinding. Again, won't fix mass incarceration alone, but I think can help make a dent and help move us in the right kind of direction. I know a speaker later is going to be talking about expungement, so I'll just be quick in saying expungement efforts are a great first step, but they need to be really robust and broad. We need to think about expungement that extends beyond just that which got made legal by state level reform. I especially think we need to be thinking about follow-up resources to help impacted individuals and communities. As I'll mention in a minute, I think we want to create institutional bodies that focus on providing record relief and restoration to really have a significant kind of impact, not just on what people are facing, but what reentry and restoration in the community really looks like. We especially need to gather good data on this as best we can, set goals and benchmarks to really not just sort of do this as a one-off, but integrate it into the way we try to approach criminal justice reform. That's really my closing theme. To do better, we need much better data at every level. And I'll give Representative Tulsi Gabbard a little love here because she is, oops, I messed up. Did I mess that up by looking at the chat? Are you guys back at the beginning of my screen? Oh, there we go. Sorry about that. Representative Gabbard put forward the last two Congresses the Marijuana Data Collection Act. To her credit, she's actually trying to get people to pay more attention to data, although her act is looking across a range of areas. I would like to see us do what I'll call sort of a marijuana prohibition harms data collection act. The Gabbard bill just covers basic arrests and prosecutions and imprisonments, but I think so much more is needed here. I want to see both quantitative and qualitative work done in this space, because doing so advances our understanding of what really the harms are from contact with the criminal justice system. It advances our advocacy efforts and can advance the remedies we choose to move forward. An important point, especially here, is, and I don't expect the industry or even the regulators of the industry to be focused on this. They've got lots of other data they're worried about and focused on for public health reasons, for all of the other topics that we're talking about in this symposium. I think it's going to fundamentally be up to the government, and it needs to be a focal point of government actors, especially those who are concerned about criminal justice issues, to demand that data be gathered here effectively and follow up. Part of my pitch here is this is a story for every level of government, right? Whether you're a local government actor, state government actor, federal government actor, looking at the harms of prohibition and how we're trying to remedy that should be integral to the systems you're building. As mentioned, it should be part of the reform infrastructure. I think social equity, to its credit, is sort of getting a bigger seat at the table more and more with newer reforms. But social equity itself often quickly becomes, how do we get folks in the industry? How do we allocate dollars to help communities that have been harmed? That's great, but we need to actually fully understand the harms there. Part of what that should include is highlighting cost savings. To me, nobody is bragging about, I'm not sure even anybody is noticing, the federal government resources saved by not sending more people to prison for federal marijuana offenses. That's a significant cost saving that should be emphasized, and that a systematic effort to collect this data can highlight. Regular public reports about these issues would be great, but we need a much better name or title, right, than the Marijuana Prohibition Harms Data Collection Act. That's just a terrible title. So just for final thoughts, how about the Harms Assessment for Reform and Reinvestment in Society Commission? What I'm teasingly describing as the Harris Commission, very much having in mind our Vice President-elect as someone who would seem to be uniquely well-positioned, both sort of politically and sort of from a policy perspective, to really drill into this story. right? Her history as a local prosecutor, her history as a statewide attorney general, her history in being somewhat criticized as a cop who furthered some of these harms, but in recent times has been very vocal and very supportive of reform. In fact, was one of the co-sponsors of the Marijuana Justice Act, from Cory Booker mentioned earlier. That's why she was in that slide. But I will sort of finish with my own sadness that I don't think this is going to happen. I think it's going to remain the case that marijuana policy in general, the criminal justice footprint of marijuana prohibition in particular, is what folks don't want to talk about. Don't want to talk about it politically, don't want to talk about it socially. It's kind of not as sexy, you might say, as some of the other topics, even in the marijuana space. And I think that's a darn shame. And I think that's why I'm grateful to have a chance to pitch those of you who took a Saturday afternoon to listen to these topics on why we all need, if we care about these intersections, we care about marijuana reform, and we want to see it be a version of criminal justice reform, that we emphasize that there's so much data still to collect because we can't figure out where we want to go unless we fully understand, where we've been and the damage that's done. So with that, again, I'll say thank you and shut off all my things if I can do that effectively this time, and move us on.
Thank you very much, Doug. I'm sad to hear that you're not going to be named to the Harris Commission. So, but we'll stay tuned. Perhaps it's possible. Thanks also for allowing us to sort of step back and look at the big picture in terms of collateral consequences and the nature of the problem. And now we're going to turn to Professor Silva, who will allow us to really dive into this question of the age of majority and its connection to the marijuana industry. Professor Silva.
Okay, thank you. And I just want to say, I really am hoping to see Professor Berman on that Harris Commission. That was a great talk. Thank you. I am a family law scholar. I'm not an expert in the law of cannabis or in criminal justice reform, but I do know Jay Wexler, so I'm here. And I've really been enjoying this conference, and I want to thank especially my co-panelists for having me among them. I do, though, know the law of adolescence, and my topic does therefore have some criminal justice overlap as well as a public health overlap. So the question I want to raise for consideration is two age cutoffs in the cannabis laws. The first is the age 21, which is the access age in every state that has a legal recreational market. The second age is 18, when a person can access medical cannabis on their own initiative in those states. So I want to say a few words about each of these ages in the broader legal landscape. The recreational access age of 21 tracks the age of access to alcohol, which is only recreational. It's now also the age of access to nicotine products. And this age reflects increasingly solid understanding that brain development continues into the early 20s. And the brain is more vulnerable to permanent harm from either cannabis or alcohol during that development. For nicotine, the 21 age responds to data showing that if you don't start using nicotine as a teenager, you're very unlikely to ever use it. Age 21 also responds to a public safety issue because people between the ages of 18 and 21 are more accident prone than those over 21. Both because they're inexperienced, but also because of those same brain development issues. In 1984, the federal government effectively required states to raise their drinking age to 21 in response to data about accident rates among those under 21. And then regulate just like alcohol has been a major part of the commercial cannabis movement. And so the 21 age for access to recreational cannabis was obvious, and the commercial cannabis industry never argued for any lower age for access to recreational cannabis. So then to speak about 18, which is the age of majority. And I think contrary to popular thinking, neuroscience is a small part, but it's not the main part of how we think about legal maturity. There's also a structure to the legal age of majority. At the age of majority, a person is an adult and has full control over all medical decision-making, as well as almost all other spheres of decision-making. So in states with medical cannabis, This means that an 18-year-old has complete control over the decision to pursue access to it. That's not because of anything special about cannabis. It's because of the full-throated legal significance of that age of majority. So here, I'm going to offer a brief history of why 18 is the age of majority. Because as recently as the 1970s, the age of majority was 21 in most states. The age of majority dropped because the voting age dropped with the adoption of the 26th Amendment in 1972. The voting age dropped, and actually the drinking age dropped to 18 for a few decades in response to that voting age drop. So then why did the voting age drop? Because we were drafting 18-year-olds, and old enough to fight, old enough to vote was the rallying cry of the 26th Amendment. But then why were we drafting 18-year-olds? Because that too was a change. And it's partly to increase the absolute number of men available to draft. But the record is clear that it was an effort to find less mature people, ones who didn't yet have wives and children. And this wasn't subtle. There were congressional explanations that said, we want to take the single men first. And at that time, you needed to move to 18 to find them. So the point being 18, not a measure of maturity, a measure of immaturity and expedience for a fairly brutal cause, but it has come to be a measure of independence and maturity legally. So despite our current commitment to 18 as the age of majority, this commitment that I've been considering in other non-cannabis contexts, there was a lot that was lost when the 21-year-old age of majority was lost. And this downward change wasn't particularly considered or evaluated, just as medical cannabis at 18 is not. And that's the way the age of majority functions. It's a powerful default framework for legal planning. So when the age for drafting soldiers drops, then the age for voting drops, and then everything else drops with it. So let me just say a quick word about some of those other things that changed. Most important, we owe minors an obligation of support, including housing, first from parents as a legal obligation, and then where that fails, from the state through the foster care system. So that age was lowered from 21 to 18 in the 1970s when the age of majority fell. Minors are generally not held to their contracts. They're protected from exploitation by an array of commercial entities, by military recruiters, and by lenders. And while the list of other examples is long, another exceptionally important consequence of being an adult at 18 is facing the adult criminal justice system. At one time, it was not uncommon to keep defendants in the juvenile justice system or in juvenile custody up to the age of 21. Today, at best, juvenile court jurisdiction tops out as a matter of law at 18. When you're under 18, there's discretionary decision-making about which system to put a person in. And that decision-making is influenced by how adult a youth seems to that court. So there's lots to talk about there, including a lot of racial disparity. But as each right is extended to younger people, there's a cost in perception of those youth that appear in criminal court. And there's actually an incredibly important movement right now to raise the age of juvenile court jurisdiction back to 21. And it's had a few successes, and it's sitting in some state legislatures. Note, youth age out of criminal offending overall, they mature out of it. So a higher threshold in the juvenile justice system can really change a person's life and significantly shift us away from mass incarceration. Okay, but medical cannabis is medical decision-making, so now it falls squarely in the autonomy zone for 18-year-olds. The 18 health decision-making might make sense for some independent reasons, especially as it relates to what are the two most pressing healthcare issues for 18-year-olds, which are reproductive control and mental health services. But it's not clear to me that either the need for medical cannabis or the medical status of medical cannabis justifies 18-year-old access. And I know the group at this conference well knows that medical cannabis access is actually structured to be self-medication because the physician doesn't actually prescribe cannabis to the patient. She instead indicates to the state that cannabis could work for what ails the patient, and then the patient uses that certification to make her own purchases and decide doses and frequencies and so forth. So I think there is a gap in protection of neurodevelopment that requires some attention here in the commercial market. And I hope this is not controversial, that I'm not trying to be controversial in saying that to some extent, the medical cannabis movement and industry is something of a construct to smooth the way for recreational use. And I would be quick to say that when medical cannabis is finally studied according to medical standards, rather than by the industry, I guess that there may be some uses that compete favorably with existing alternatives, but it may not include many of the uses that are now being called medical. And that's a muddy area and a muddy line, which may be comfortable for the emerging cannabis industry, but my sense is it isn't comfortable for many medical researchers. And I'm saying I think it has implications for 18-year-olds. And here's how I might support my observation about medical cannabis functioning as a device to reach recreational cannabis. Because when states had medical cannabis only, there was a lot of medical cannabis. There were a lot of medical cannabis users. But when those same states added recreational cannabis, the majority of medical users moved from medical to recreational. There was an exodus from medical. So that suggests medical demand was in large part recreational demand. For example, in Oregon, almost 2/3 of patients gave up their medical cards, and there had been 400 medical-only retail shops in Oregon. And after recreational was approved, that number fell down to 2. In Alaska, there was a 63% drop in the number of medical users as they moved to the new recreational market. And this is true despite the fact that medical typically has benefits to users, lower taxes, and therefore lower cost to the users, and also better products, higher concentrations of THC, and a wider variety of delivery methods. So if medical has been, to a significant extent, a conceit for recreational, it did fill a gap in demand before recreational was allowed. And I'm not judging, it's a hard regulatory environment, but I am saying that this should lead to some special attention to 18-year-olds, because on this view, medical might become slowly obsolete unless it can find another demand gap to fill, like that recreational demand. And so that brings me to the question, why can 18-year-olds still access medical? And in a related matter, why wouldn't the young cannabis industry work to make medical access more difficult until age 21 by way of securing a good reputation? And I think partly they are invested in the authenticity of the medical construct. So even as the industry moves more fully into recreational, there's an attachment to the ideology that brought us to commercialization, which is medicinal. But I do worry that there's a harder point as well. I think we have to consider the possibility that the cannabis industry, both recreational and medicinal, wants to be able to sell to 18-year-olds, and that would give oxygen to medicinal cannabis. Because the other entities that are regulated under 21, alcohol, tobacco, nicotine products, those industries did not want to lose their access to 18 to 21-year-olds, and they have fought it. And that's because the later an adolescent or a young adult initiates use of these products, the less likely they are to abuse them, to develop substance use disorders, and in the case of tobacco, to ever use it. So when those access ages are raised, the businesses are losing a lot more than just 3 additional years of marketing, and that's the key. They're losing access to the creation of lifelong high volume users who the public health community calls misusers, but who are really important customers to substance sellers because of their reliability and volume. So people who don't initiate nicotine, alcohol, or cannabis under the age of 21 are much less likely to initiate later and less likely to misuse later. So postponement can be prevention. And if you do imagine the cannabis industry as a big billionaire-driven industry, then we should at least be able to ask what it looks like if it does track nicotine and alcohol in terms of the business model. In those cases, the underage users are really important to the business model. Misusers, abusers buy more and more reliably. So to conclude, I just want to bring this back to my larger interest in the law regulating adolescence and to share what is really my main point, which is that there is a tendency to think about questions surrounding 16 to 21-year-olds as questions of their rights and their capacities. What does neuroscience justify? How do high-capacity teenagers themselves act? But in reality, the law that infantilizes them mostly constrains third parties, even more than that law constrains the youth themselves. So they constrain the military in recruiting and drafting soldiers. They constrain commercial entities and internet platforms from exploiting youth. They constrain the tobacco industry from addicting youth to nicotine. And they constrain, to some extent, law enforcement and courts in their treatment of youth. And I'd like to encourage people generally to be skeptical of an institution, and especially an industry, that promotes the rights and autonomy of teenagers. And in this context, that means the autonomy of an 18-year-old to access commercial cannabis using the medical construct. As medical users melt into recreational users, we should acknowledge that 21 might be the appropriate age of access for either to commercial cannabis. And I thank you and the organizers and those who are staffing the platform today on a Saturday.
Thank you so much, Professor Silva, and reminding us about the business model and how that may drive access and decisions around access. And with that, we're going to move to Professor Steiner, who will return to this issue of the question of sealing and expungement that was raised earlier and do a deeper dive in exploring responses. Thank you, Professor Steiner.
Great. Thank you. And thank you to BU Law, as was mentioned, my alma mater. Who knew it would take the vehicle of cannabis to reunite us in this fashion? Thanks to BU's Law Review, and in particular to Jay Wexler for really making this all possible. As the, I guess, penultimate panelist, I can really say this has been a truly enriching 3 days of conversations. I'm eating it up like the catnip that it is. And I feel very fortunate to be here with you all, in particular on this panel with Doug, Kate, and Tamar. And I will sort of give a spoiler alert that some of what I have to say is sort of repetitious of what Doug said, and that's not surprising. I was showing Doug my dog-eared copy of his 2018 Leveraging Marijuana Reform to Enhance Expungement Practices. He really is a leader in thinking about this very issue. I'm going to push back on one point Jay made at the conference outset. His title works quite well for me, and so I'm going to organize this by talking about lessons from the past, by looking at what's transpired in this sort of vast and burgeoning arena of criminal records relief, and focus in particular on expungement and then applied what we've learned to propose some thoughts for the future. In doing so, I'm not sure I'm going to have much more novel to say beyond what Doug has said, but I do have a few angles that I think are unique. So, and then as someone in the lane of cannabis education, I absolutely love the term cannabis competency that Dr. Rachel Knox used on day one. She was discussing it in terms of public health and the competency that those in the medical community needed to be competent. And I'm going to stretch that term to legal competency, because as we think about some of the best practices in this arena, many of them, as I see it, relate to our own ability as legal professionals to counsel people in cannabis. I've had the opportunity to think a lot about cannabis records relief. As you can see from my shirt, I'm wearing a National Expungement Week 2020 shirt. I'm on the faculty at Western New England University School of Law, where we recently started an Institute for Social Justice. And we've been involved in practical lawyering to assist individuals through the process of sealing and or expungement of their criminal records. And I will readily admit that because I focus primarily on civil litigation or civil law, I was not sure when I began what sealing was and how it differed from expungement. And as it turns out, I'm not alone. So, you know, one of the things I learned is that many folks are entirely unaware or really have only a vague notion of whether they even have a criminal record or what's on it. They have a very limited understanding, if any, of what record relief rights exist for them. There's a recognized uptake gap that Doug focused on in his 2018 piece. Many people who are entitled to relief cannot or do not access that relief. And also, there's a growing army of well-intentioned, very dedicated folks who want to get involved, and they need legal cannabis competency to do so. So I want to pay particular respect to all the folks from National Expungement Week, the judges, the lawyers, the DAs, and all the many policy influencers who are thinking about this important issue. So let me turn now to the problem of the lingering criminal record. A criminal record is a relatively permanent written summary that documents a person's arrests and convictions, and it's maintained by the criminal justice system. And not surprisingly, this does vary from state to state about what's included on it. Many states are experimenting in different approaches towards this right now. So what I'm going to describe is what's generally the case, though of course there could be particular state exceptions to this general situation. Criminal records, as I said, are persistent. So without some form of record relief, they linger and operate as a cloud on someone's personal title, branding them as criminals, even where there have been arrests and they've been released without charges, even where charges were filed but dismissed by the prosecutor or the court, even where charges are brought and the accused was acquitted. Sometimes there's no indication in the official record of whether or how a criminal matter was resolved. So the matter remains open and kind of pending as an outstanding matter to the onlooker. This could be attributable to administrative oversight or error, or just because it just has not been recorded in some way as resolved. So there are many scenarios that produce a criminal record short of a final conviction after exhaustion of administrative appeals. Many people have a cannabis criminal record. It's hard to drill down the exact numbers, and I think Doug certainly did a very emphatic slide on that. There are some things that we do know, and I'll try not to repeat Doug's statistics, but according to the Sentencing Project, between 70 and 100 million Americans, nearly 1 in 3, have a criminal record of some type. And even that statistic's a little dated. That's really based on 2015 FBI Uniform Crime Reporting statistics. According to the ACLU's April 2020 report, which I know Doug drew a lot from just 2010 to 2018, law enforcement made more than 6.1 million marijuana arrests. The ACLU study further found that these arrests were rising in recent years from 2015 to 2018, driven by states in which marijuana was still legal. 9 out of 10, they found marijuana arrests were for possession. And unfortunately, and as many panelists have noted, and in many respects were focused on this thanks in large measure to the groundbreaking work of Michelle Alexander and others, we know that there are what the ACLU has termed stark racial disparities in marijuana possession arrests, with a nearly 4-fold disparate impact on the Black and Latinx communities, even though Black and white people use marijuana at similar rates. I'm always searching for these statistics. So yesterday I got some more catnip from Bo Kilmer. If we look at arrests per cannabis use per day, the Black to white ratio is roughly 3 to 1. So I can officially quote Kilmer et al. In progress from yesterday. A lot of great work has been done in this arena. And I noted Doug's work, Tamar's work at the Drug Policy Alliance. And I've been focused a lot on the Collateral Consequences Resource Center. They've been tracking state developments through the Restoration of Rights Project. So I really recommend that to everyone. And if you haven't yet had a chance to get a copy of the recent empirical study in June 2020 out of the Harvard Law Review by J.J. Prescott and Sonia Starr, Expungement of Criminal Records, an empirical study, I highly recommend that. I'll be talking about these references in a little bit. So Let's consider the broad organizational taxonomy of record relief. Record relief is a term comprising the various remedies that revise or supplement a person's criminal record to reduce or eliminate barriers to opportunity in civil society. It can be record supplementing, adding to a record, executive pardons or judicial certificates of release are record supplementing types of relief. And record relief can also be record revising. Sealing and expungement are record revising relief. Sealing refers to limiting who has access to a criminal record. Criminal justice agencies such as police, prosecutors, and courts have broad access to criminal records. Members of the general public might, it depends on what the sealing remedy typically covers, but one of the key components of sealing is to limit access to other kinds of members of the general public, and usually just limit it to criminal justice agencies. But again, this can differ from place to place. Expungement, on the other hand, refers to complete destruction of the prior criminal record. And typically, this means that records can't be accessed through the criminal records database by anyone, employers, courts, police. It might still exist on the internet. I'll talk about that at the end. But expungement is by far the gold standard because it most assures elimination of the record and, as best as possible, mitigation of the many collateral consequences that exist. And indeed, there are significant economic and social consequences to having this kind of criminal record. That's really an understatement. I loved the number that Doug put up there. I didn't even know that there was an actual tally of 650 some odd collateral consequences. But financially, having a record can be devastating for the individual as well as society. And these individuals are hindered in their ability to find jobs, employment. There are reduced opportunities for advancement in terms of promotion. They're excluded entirely from certain kinds of industries. From a professional licensing standpoint, including accessing the legal bar, having a criminal record could serve as a barrier to professional licensing entry. In terms of education, you might not be able to attend a particular school or receive financial aid. In terms of housing, many landlords screen for a potential tenant's criminal records. Public assistance might not be available. And there are cross-generational collateral effects. The collateral damage of having a criminal record creates socioeconomic barriers associated with a parent's criminal record. And this can harm a child's long-term well-being and social outcomes. Reduces barriers to opportunity. Doug mentioned a few of these. Civic engagement. You might not be able to volunteer at your child's school as a result of a criminal record. You might not have a driver's license. Your driver's license might get suspended. This can certainly affect voting and jury service. Adding fuel to the fire, criminal records can be used to target non-citizens for deportation, which severs ties within migrant communities. There are tremendous stigma and discrimination from being marked as a criminal, and just general sort of trauma that comes from all of this. Additionally, having a criminal record can stop one from owning a gun. So tremendous number of collateral effects, and not surprisingly and quite sadly, this is amplified for people of color and people of lower socioeconomic status. Now, states have increasingly passed record revising relief, some for the first time and others really continuing to expand on existing eligibility or improved procedures. They did this in many ways outside the context of cannabis. So from 2009 to 2014, we had at least 31 states that had some form of expungement and sealing remedies, and the momentum is growing. Real focus in the marijuana specific realm began somewhere around the time of adult use legalization, with the first significant effort to remediate cannabis records in many ways beginning on or about 2016, when California's 2016 legalization ballot measure included provisions authorizing record sealing. This, I think, is what catalyzed Doug to write his 2018 essay and urge states reforming cannabis laws to be particularly concerned with remedying past inequities and burdens of mass criminalization by offering robust, retroactive relief for prior marijuana offenses. And he also urged them to dedicate resources generated by marijuana reform, like the taxes, to create and fund new institutions to assess and serve the needs of a broad array of offenders. So really, that was quite thoughtful, and thanks to Doug, policymakers and reformers have really picked up on this and started to engage in more, though we're not fully there, movement. The momentum continues, and so I've been looking at the CCRC's 50-state tool. That's might be off a state or two post-election, but presently there seem to be about 17 automatic expungement or sealing states, about 7 states that expedite non-conviction relief through motions filed at the time of dismissal or acquittal, and about 26 states in DC which have some form of relief but still require court petition processes before they'll seal or expunge non-convictions. Many of these jurisdictions place substantial restrictions on eligibility for relief, and they have procedural hurdles like hearings and filing fees, which certainly creates a big bar to those who want to take advantage of it. The federal system and Arizona lack a non-conviction expungement law, though Arizona allows non-convictions to be set aside, is what they call it, if the subject can show that the charge was wrongful. So we're getting there, but we're not there yet. So what lessons can we draw from this history? The first, I think, is that record revision works. Not fully, but it does work. And such remedies promise to alleviate the stigma and discrimination that are produced by a criminal record in social and economic contexts. In the area of cannabis records, I think it's important to debunk the myth that there's an important public safety right to know about prior records, and such offenders are in some way going to be recidivists. And if we look at the Prescott and Starr empirical study, they've done important work with regard to empirically debunking this. What they found is that individuals with sealed or expunged criminal records actually commit crimes at a lower rate than the general adult population. In what they did is they took a look at what was going on through a comprehensive study of expungement recipients and compared their outcomes to those of non-expungement recipients, and found that those who do obtain expungement actually have extremely low subsequent crime rates, comparing favorably to the general population. Doug mentioned this, but this can also benefit the economy. The expungement recipients experience considerable gains after they receive this kind of relief. And we have to think about the cost on society if they're not employed or underemployed, which is something that in many ways exacts quite a toll on society. Another lesson is that we have an empirically demonstrated uptake gap, and that's that conventional expungement sealing procedures require a burdensome and expensive court procedure that only a small percentage of those who are eligible will ever seek. According to the Prescott-Starr study, among those legally eligible for expungement in Michigan, just 6.5% obtained it within 5 years of eligibility. A lot of this relates to the complexity and cost of doing so, especially in petition states, and the fact that they don't know necessarily about their legal rights. So as Doug mentioned, I totally agree that we need to broaden the eligibility requirements for cannabis convictions The movement right now is piecemeal, and there are really broad swaths of records that are ineligible for record relief that we need to consider. So in terms of instructions for the future, I know I'm running out of time, so I'll just try to do this very quickly. Automatic, many people have said this so far, I think automatic retroactive expungement, not sealing, covering certain convictions and certainly non-convictions, using a funding mechanism through the marijuana tax is a very, very important move. Doug had talked about a commission on justice restoration. Maybe that's his new Harris Commission. I'd be interested to hear that at the end, but I very much like that idea. Even short of sweeping federal reform of the type proposed by Cory Booker in the Marijuana Justice Act or the 2019 MORE Act, I think, and I agree with Doug on this, that states are going to be leading the way. I think a key will be to try to encourage states to not pursue sealing, but to pursue expungement, to do it retroactively, and to do it quite broadly. Thinking through not only non-conviction records, but conviction records for nonviolent possession. Thinking through the amount threshold. Right now, expungement or sealing is really often limited to prior records involving possession of relatively small amounts, say up to 2 ounces or something like that. The notion is that this amount reflects what's legal within those states, and higher amounts might be reflective of someone that was trying to sell. But I think we need to have conversations about whether this continues to make sense. We aren't criminals if we have more than 2 bottles of alcohol. So we should be thinking about those threshold amounts. Reconsider other types of restrictive eligibility criteria and waiting periods. Many states include disqualifications based on some unrelated record, like prior convictions or prior sealing. So if you have another prior conviction or prior sealing, then you might not be eligible. If you get a bare arrest during a waiting period, you're ineligible in many states. If you weren't a juvenile, you might not have the ability to tap into some of these things. Additionally, some states charge fees and require the expungement or sealing applicant to go through complex procedures or wait long periods of time, and those waiting periods, complex procedures, and fees should be rethought too. In terms of best practices, it's critically important to ensure that people obtain a court-certified copy of their expungement record. And this is true even for automatically expunged or sealed records. First of all, to do this for history's sake, it's important to keep some kind of record, some data about how many people were arrested, obviously without their names or anything like that, just how many people were arrested, what their demographics are, and what their legal issues were. The individual should maintain this record in case it's needed in the future. So it's important because if this individual has a legal matter where they need to prove up what happened later on, once it's expunged, the record's gone. This can certainly be the case with immigrants. Individuals who need to apply for a green card or try to change their immigration status need to know their criminal record history will be reviewed, and they might need a copy of their record to prove what had happened before. Sometimes there can be a disconnect between the state expungement and what's going on at the FBI record level. And so sometimes there has to be some clearing between those two. So the record might not reflect what's happening at the FBI level, and you're going to actually need a copy of that expunged record in order to sync the two. And finally, I just want to talk a little bit about this cannabis competency. We focus so much on knowing our credit history, but what about our criminal record history? I think it's important that we start talking about these things more, making it more of a habit to have individuals obtain their criminal records, look to see what's on it, clear any issues if they're eligible, and educate individuals, especially once expunged and possibly sealed, that they may be eligible to respond no if they're asked whether they have a criminal record without any kind of penalty of perjury. And to the extent states don't have that, push for that policy. I'll sort of leave off by talking about the ongoing issue of digital punishment. We need to think about whether there's a viable remedy for digital expungement. When you expunge these records from the criminal justice official record system, that's not expunging it from the internet, where these things can really go on to have a life form of their own. And so I think we need to consider and think about whether there's a viable remedy for digital expungement. Can individuals seek expungement by petitioning the operators of websites to remove these references? Can there be some penalty for failing to do so? Is this even feasible in this day and age? And so, I'll just leave off there, and just maybe with a dangling question about whether we are at, or at least getting to the point where we might say that the human desire to use cannabis medicinally or euphorically perhaps is not a criminal matter. And prior records, at least those that were nonviolent, should be expunged. Sealing doesn't get at it, but expungement gets us a long way there towards eliminating collateral consequences. And with that, I thank you for your attention.
Thank you, Professor Steiner. Thank you also just for highlighting the importance of criminal record advocacy efforts. And also, I hope we're able in the Q&A to get at this, but the continuum really that exists in terms of post-conviction relief, in terms of both offenses and types of relief available. So just as a reminder for those in the audience, please feel free to be thinking of your questions. You can go ahead and pop them into the Q&A as they come to you. And with that, I will also introduce Professor Todd, who will sort of leave where we are now and lead us into a discussion of policing and criminal justice reform. Thank you.
Thank you. Thank you so much. And I'll try, some of the points about the criminal justice reform were touched on by Doug. So I will try and move it along so that we have time for question and answers. But I just want to say one thing, first I want to say thank you to Jay Wexler and BU for hosting this panel. And I love learning the different perspectives. And I learned something that has been bugging me for months just now during this session. And that's, I just spent the last year working on the Montana legalization campaign. And in Montana, it required 2 initiatives that we had to run. One was a statutory initiative that legalized and regulated marijuana for adults 21 and older. And the other was a constitutional initiative that amended the Montana Constitution because it had this provision in it saying the age of majority in Montana is 18 for all purposes and there was this exception other than alcohol. So we had to do a whole separate constitutional amendment initiative, which required many more signatures, a lot more money, and a lot of stress over what was going to happen if that one failed and the statutory legalization passed. And so I was pulling out my hair wondering, why is this in the Montana Constitution? Why did they put it there? Montana readopted its constitution during a constitutional convention in 1972. And I even went back and looked at the legislative history to try and figure it out because it was, causing so much additional money and resources on the campaign. And now I just learned that I think it was the Vietnam War in 1972, which is probably why they put in this age of majority. So that is an interesting bit on the history of that. And both of them ultimately did pass. So at least for recreational, the age will be 21 in Montana. But the interesting thing that this conference brings together, and one of the things that is so interesting to me about marijuana law that frames this, is that it's the one you've often thought, is there another reform movement, a racial justice, social justice, criminal justice reform movement that marries that reform, the criminal justice reform and the racial justice reform, with the creation of this new economically promising industry where people stand to make great profit and where they're going to develop, sell, and market a commercial product that could help some people, harm some people, and in both cases requires regulation and taxation. And it brings together all these interests and all these drivers for reform, which, depending which is at the forefront, can really elevate which takes precedence and where focus and attention is paid. And, for since the start of reform, there's been competing interests and competing reasons why people come, certainly for the increased tax revenue. And I think marijuana legalization in 2008 with the economic collapse really took a leap forward because of interest in tax revenue and generating tax revenue. Of course, compassionate access for people who were sick. Prop 215 was driven by compassion for AIDS patients in San Francisco. And then of course, CBD driven for compassion by children with epilepsy. A desire for regulated market for safe products, a desire for more responsible spending of law enforcement resources and of state revenue. And as I mentioned, I'm fresh off working a set of new ballot initiatives this cycle, which included Montana and others. Focus actually in more conservative states like South Dakota and Mississippi and Montana and Arizona. And front and center are still these same arguments about tax revenue, the benefits of regulation, and these other drivers for reform that politically definitely carry the day and were front and center. But also, I think, is a powerful message, and this is just because I know the public opinion research in those states and in the other states, and this is true across age and party and religion and demographics, is that at this point in time, a central tenet that folks continue to believe in and think is important, even though it's not what the paid media and those campaigns focused on, is the concept that we shouldn't continue to punish or hold back someone for minor marijuana related conduct. Certainly that issue of collateral consequences going forward is something that there is very, very broad consensus on of people that disagree with that. And also very strong support for some of the other criminal justice reforms, the initiatives, of course, they didn't provide legal access for minors, but they decriminalized a lot of conduct for minors. So marijuana is bad for kids, but so is ensnaring them in the criminal justice system. And that had very, very wide support, maybe higher than any other specific piece of the reform in the initiative. So I think there's very broad support for the criminal justice components. And of course, given the history and what Doug touched on, the foundation for why marijuana was criminalized and its role in racial disparities in the war on drugs. That's always been a central piece that has motivated reform. But I do feel like it's never been centered in the driver for reform. And when it's not the driver for reform and there's other interests like the tax revenue and the compassionate access and medical access, it doesn't necessarily take the place front and center that it deserves in consideration for how the laws should be shaped and the policies should be carried out. And I've begun to fear that, as we move into a new era where I think more of the reforms, more of the lobbying at the state level, maybe more of the reforms, if there's future ballot initiatives, will be funded perhaps more by industry or by other interests, whether this, the importance of using marijuana legalization and the reduction in penalties as a driver for furthering criminal justice reform could be reduced in importance or take somewhat of a backseat. And I think there's a perception that it's taken the, that it's not centered for a number of reasons. I mean, part of the reason is just simply perception. I think a lot of the laws do go far in actually reducing penalties and criminalization and including retroactivity, or even when they didn't include retroactivity, spurring the legislature to then pass laws that expand the retroactivity provisions. But certainly, many of the reforms have happened through direct democracy, especially in initially whiter states. And the criminal justice and racial justice issues have not been at the forefront of those campaigns or necessarily even at the forefront of the policy development, which is concerning. And I think also there's somewhat of a failure to evaluate or center the analysis of the impacts of the criminal justice reform. So there's a lot, certainly in the mainstream, although there's definitely academics look at it, more evaluations focused on the tax revenue raised, the size of the remaining illicit market, than I hear in terms of the reductions in arrests or other collateral consequences, and the success and the failure of different measures and different policies are also often framed in terms of some of those other drivers for reform around revenue generated, reductions in illegal market, rather than on the number of records expunged or the reductions in arrest or felony convictions, those types of things. And then another part of the reason why I think there's a perception of not the centering of criminal justice, or the central role that criminal justice reform should play in its connection to marijuana reform, is what, and Doug mentioned this, although he argued a lot of the other factors around it, but there is the perception that few people go to jail for marijuana or spend significant time for marijuana, or that marijuana law reform is not going to make a big dent in the actual rate of incarceration or to address mass incarceration, although it certainly addresses mass criminalization because of all the collateral consequences, what we learned about. And that, I think, is one, I think that's less true as we, as Doug demonstrated in the data, but it's also less true as we move into some more conservative states in terms of reform. So in South Dakota, for example, which just legalized its last cycle, arrests, of which people are incarcerated for, make up 10% of all the arrests for anything in the entire state. So you're talking about, with this reform, making a dent in overall arrests of 10%. Secondly, it's more harshly punished. I mean, South Dakota is the only state where the ingestion of a controlled substance is a crime. So not just possessing marijuana subjects you to prosecution, but actually having THC inside your body subjects you to prosecution. In Arizona, another state that just enacted reform last week, legalization, it was the only state where possession of any amount of marijuana still was a felony offense, even of the tiniest amount. So as reform spreads more broadly, we do get to states, and then when you get to states where there's habitual offender laws and things like that, certainly it does add time. But there's also, I think, significant other reforms that should come with legalization, other than these focused on reducing penalties or just the time served or the number of people who are arrested and prosecuted for a marijuana only offense. And we need to think more broadly and more creatively in terms of the role that marijuana plays in relation to time for other convictions that people are convicted of, and additionally the role that marijuana plays more broadly in policing and creating justifications for search that then lead to arrest and prosecution for other crimes. So there's three, and Doug already hit on two of my three. So I'll go through quickly of three areas that I want to identify that I think we should be looking towards significant reforms, certainly with legalization, but also potentially without legalization in jurisdictions that aren't ready for a commercial legal market, but where these reforms would still be incredibly important. So first, as I just mentioned, is the use of marijuana as a justification for stopping and searching, and the odor of marijuana, or the smell of marijuana, being the basis to stop and effectuate a stop and frisk of a person or a search of a car. Even in legal states, the smell of marijuana alone is used to justify stops and searches. And although there's some case law on it, some Supreme Courts, Massachusetts and Vermont, have held that smell or the odor of burnt marijuana by itself does not give rise to the right to search a car. And in Pennsylvania and California, and also there's a few lower court cases that are indicating that, although it's split. But I've long thought that part of the reason why law enforcement is so opposed to marijuana, some law enforcement is so opposed to marijuana legalization, marijuana law reform, is that it stands to remove an incredibly convenient and incredibly useful tool to policing, because odor is not something that you collect and tie up in your evidence bag that can later be examined by an objective judge and determine whether that was a basis. It's subjective, it's smell, and then it goes away. And to be able to say, I smelled marijuana, there was the odor of marijuana, that justified the search, thereby which I found the gun and then effectuated the rest. And that's the basis for the rest being valid. It's just a very, very useful law enforcement tool that I think is widely used to justify a large amount of police-related stops and frisks. and we see the pushback on that. So I'll just give an example. In California, for example, it's in the lower courts. The decisions have been split on it, but we've seen law enforcement come in and actually say, we have now have a special training. We're now specially trained where we can decipher smell based on quantities over an ounce rather than less than an ounce, or we can smell from outside the car whether it was an enclosed container or not. So it's to lengths to justify this as a basis for search. And as I mentioned, this is legalization didn't solve this issue in a number of states, but we have seen that this is a possible reform even short of legalization. And Virginia now, there's a bill on the governor's desk that the governor's looked at. I believe he's going to sign it imminently, that actually prohibits search and seizures based on the odor of marijuana alone. So even short of legalization, it's a police reform that could be used to reduce searches on that basis and reduce the number of police interactions. Second, and Doug mentioned this, is to stop violating people on probation, parole, or other supervised release for marijuana related activity, right? So you may not get a huge amount of time for your initial marijuana possession arrest, but if you are on supervised release for another offense and you have a technical violation involving marijuana, you can be revoked and go back for significant time. I think this is a huge driver of incarceration and revocations based on technical violations. The latest batch of initiatives some of them contained affirmative language. Montana contained affirmative language that limits the ability to revoke or violate someone based on marijuana conduct alone. And I believe Arizona's initiative doesn't have that specific language in there, but there's case law that was developed in the context of medical cannabis and probation and parole that is the same language. So I think it may still hold there, but I think that would be an important reform, and one that also could exist without legalization. There could be a reform to what technical violations people are being able to revoke on. And then the third, and Doug also touched on this, is just the need to collect data in both of those areas. So we don't know how many people were violated on a technical violation, often even whether it was drug related, and then within drugs, whether it was marijuana related. Certainly a huge number of violations are technical violations. And then when you extrapolate the use rate for marijuana versus other substances, you can guess that a large number are marijuana related, but there's just not data there. Similarly with stops and searches, we don't know the basis for most stops. We don't know, there's no comprehensive data collected on certainly when people are stopped and searched and then let go, what the outcomes of those cases are. That data is not collected by police departments anywhere that I could find. Occasionally there's been a court order that's ordered one city or one police department to track stop and frisk data, but there would be a lot to learn there. And then finally, just in this vein of criminal justice reforms that I think should be charging forward, even before we get to legalization, or certainly in conjunction with legalization. And I think on the federal level, there's a number of things that could happen short of amending the CSA that could happen quickly and are maybe more impactful than just decriminalizing under federal law, since most possession arrests are not for federal violations, they're for state and local violations. So in addition to decrim for federal offenses and of course expungement on the federal level, I think funding and incentivizing programs to expunge state marijuana convictions, removing marijuana convictions from any state, so legal states and non-legal states, as a basis for federal collateral consequences. So including in the context of immigration, denial of naturalization, grounds for deportation, refusal of entry into the US, removing marijuana conviction for denial or eviction of public housing as a basis to deny employment or discipline of federal employees. And then I think in the area of policing, and that's of course for legal states and non-legal states, the federal government could do that for marijuana convictions. And then in the area of policing, as a condition of federal funding and federal grants for joint state federal task forces, require that states end enforcement of marijuana possession or reduce low-level marijuana enforcement under their state laws to end or reduce racial disparities in enforcement and eliminate consent searches, ensure that marijuana arrests are not included in performance measures, numerical performance measures, and to require collection of comprehensive data on stop, search, and arrests, as I mentioned, with the demographic information and the outcome. So lots of ways that I think the federal government could exercise it, well, remove its collateral consequences and exercise its spending power in a way that is aligning state and local law enforcement on the same priorities. And then I'll just add one final thing. And Doug also mentioned he thinks a lot of these things should apply to all drug offenses, drug possession offenses, and I agree. And I think that one really important piece of why I think marijuana law reform needs to stay centered as and identified as a criminal justice reform issue is I think we now are in a moment where we have broad political support for these reforms in the context of marijuana, and it allows us to build models and templates for how to reduce criminalization, reduce records, reduce collateral consequences in a way that will then be able to be extended to drug arrests more broadly in the future. And I'll stop there. Thank you.
Great, thank you, Professor Todd. And I'm going to welcome back our panelists. We have one question already, and feel free, we only have a little bit of time, but feel free to insert your questions in the Q&A function. So this question is coming from Caitlin Schneider, who says, I'm interested in hearing more about how the interplay between the age of majority and the criminal justice system. Professor Silva mentioned that perhaps the age for recreational use should be 21 because it reduces the risk of abuse. But how should we address inevitable underage experimentation and habitual use, since it seems apparent that referral to the criminal justice system is not the appropriate solution? Professor Silva, do you want to lead us off with this one?
Yeah, I mean, I'm really only interested in access to commercial cannabis. I share, I think, the view of the vast majority of people that, that there should be no enforcement against access and possession among minors. But, there were 1,000 small steps along the way, home grow, lots of different things that, off ramps and different ways this could have been handled. That's, and I think Tamara made this point at the end about who is now going to be running the initiatives. And it's that I'm actually concerned about. So no fan of, criminal enforcement. But I don't want, what I'm concerned about is that looking at that industry through the same lens I look at the tobacco industry, I'm concerned about their hope for that market between 18 and 21. And I think that's just a very different thing than asking questions about criminal enforcement. And I hope that's clear.
Do others have thoughts on this issue?
I'll just add quickly. I mean, to me, it's a really complicated, that 18 to 20-year-old is really complicated little segment because, so the initiatives, it's easy, decriminalize for minors. Nobody wants minors to be going to prison. There's also a problem with school discipline that hasn't really been addressed of expulsion and expelled. And it's easy to say, it's not legal, so we don't want people to go into prison, and we'll put revenue there for, instead you go to education or counseling or something. But the 18 to 20-year-olds, it's harder because you don't have that parental piece. They're not within a school context. They're not legally a minor. So how do you not criminalize that segment, right? Because you also don't want harsh penalties for 20 and 21-year-olds. Plus, they're like a huge bulk of the segment of the arrests anyway, are that age group that are actually being left out of legalization. But you also don't have like the parental or oversight because they're adults, right? Legally, they're adults. So, and especially in terms of medical, how you would give medical access to a patient in that age group who did need it, but can you require for that age group of parental consent? So I think it's a really tricky area for the reasons Kate identified and legally to navigate.
And I'm sorry, because I wish I'd said this. I just want to add that if anyone's interested in the advocacy work here, it is the Raise the Age campaigns. It is the Raise the Age of juvenile court jurisdiction to 21. because really that changes lives. I mean, because, it's just, as Tamara's saying, that is the population that offends on anything. And people just outgrow it. If you open prison to if you just let everyone out of prison who's 30 years old, nothing bad would happen. I mean, I'm sure that's an exaggeration, but I mean, not such an exaggeration, right? I mean, it's really a developmental thing by and large.
I think that's right, as long as you make sure they're prohibited from alcohol and can only get marijuana, because there's the crime profile to some degree. But joking, everybody, but that's okay.
So I have a follow-up for the group. I was very happy to hear the focus on both expungement, but the breadth of offenses. And I'm curious to ask you, having some experience myself with vacatur laws in Massachusetts and trying to have them be broad and receiving pushback within legislatures to do that around especially offenses that may involve victims. What challenges have you found or lessons learned from trying to pass broader vacatur or broader expungement legislation?
I think there's so many dimensions on which this is really challenging. It's why, and thanks to Julie and others for kind of emphasizing building some institutional structure to study these issues, because uptake rates are very, very low if it's not an automatic process. But if it's going to be an automatic process, you're going to have much narrower categories of who's going to be made eligible, right? And how you want to balance that. One of the things that the Star Prescott article is fantastic, but I worry a little bit that the really positive outcomes are themselves skewed by who goes and does uptake, right? So that's the people who are motivated and have reasons in their lives to move forward. At Ohio State, we're working on a pardon project, and it's wonderful to see people sort of super motivated to get a pardon and wanting to volunteer and do all sorts of stuff. It's mostly, in fact, informal collateral consequences that are driving them to want to seek a pardon. But it's the availability of a process much more so than just sort of a waving of a wand. And so I think there's just going to be so many intricate questions about how you construct it going forward. And I quite strongly hope, this is another variation of building infrastructure, that all of the organizations that are busy working on second chance clinics and things like that, lots of law schools, sounds like a new institute, which is wonderful, is part of building that infrastructure, and law students who see the opportunity to do this work. But then you need a funding scheme that's persistent, right? That could be a expungement Gideon, right? It's not far-fetched to think, we guarantee you a counsel to prevent you from getting a conviction in the first instance. Why shouldn't you also have a counsel to exercise your remedy to get that, taken away? If you have the state paying for counsel that way, they can argue these margins effectively and build towards broader and broader mechanisms. But it requires not just doing, the legal work, but then also building the advocacy for a broader set of folks really benefit from this remedy, and the society at whole also benefit.
Yeah, from what I see, there's just a general movement towards more acceptance, of sort of cannabis law, cannabis legalization, cannabis regulation, and going in with that, but sort of a step behind is expungement, right? So first there's sort of like the popularization of cannabis legalization, first decriminalization, medical, adult use, and now we're starting to see sort of, bringing up the tail end, more acceptance of these types of record revising remedies. And so I'm hopeful that, I'd actually be curious to get Tamar's take on this particular thing, as you see citizen ballot initiatives, and then, that also sort of drives the legislatures as well, whether we'll see citizen legislators that are incorporating more and broader expungement provisions in, because they're piggybacking off what has already come before.
Yeah, I'll just add quickly, if we still have time, just two quick things. One is that one area I do actually think there's a little bit of a political divide, and that I've seen the public opinion research that conservatives have a harder time with expungement because of a concept that, like, well, it was illegal at the time you did it, so we're not going to go back and change. It was the law and you didn't follow the law, but moving forward, I'm cool that now it's not going to be illegal anymore. So I think there's a little bit of a political thing there, but I actually think there's very why, it's politically, it's completely changed in the last 5 or 6 years. I think attitudes towards expungement, where maybe 6 years ago, it was kind of politically risky. Now I think it's very widely accepted and widely supported by voters and state lawmakers. The one piece that's tricky, and this is the problem I've had with state legislatures, whenever we've tried to do it, especially when you do it automatically, the courts say we can't do it. That's too hard. No, and then they'll say maybe if you give us $20 million to expunge it automatically, we do it, but we still probably can't. I don't think so. The record, we give out the conviction super easily, but it's really hard apparently for them to undo it. Just the system of how it's kept and everything that is met with huge resistance. California was well, you're going to have to do it anyway, figure it out. So, maybe they will, or maybe they won't. I'm hoping that it's a process that leads to developing a system by which we can undo records that could then be used more broadly. Marijuana will be this process where there's a learning about how to do it. But the big resistance, in California, and we're seeing now in New Mexico, to doing the automatic expungement is not political. It's just the saying it's so expensive and it's so hard to do it automatically. We can't figure out how to do it.
Well,
Which is
that's-
legitimate.
Yeah.
It's a legitimate concern, so you do need to put that funding piece there, and there's where it's not popular, but drawing it from the tax revenue seems like the obvious go-to.
Yeah. And I also like coupling it with a revision in the law that says, you want the record expunged, but you can also include language that says you can't use the prior conviction for marijuana in any of these contexts against the person. So to the person who doesn't go in and have it expunged, or it takes too long, you still have this added protection that you said in the law. This can't be a basis for denying employment or taking your child or these other pieces. So I think given the difficulty in actually implementing expungement, it's important to also have that other piece.
Well, thanks everyone. And thanks for ending us on a somewhat positive note about how marijuana law can pave the future for criminal legal reform. And also we'll think about the expungement Gideon. So I just want to say thank you to our panelists, and also once again to thank the BU Law Review, Jay Wexler, all of our wonderful attendees who stayed around even 5 minutes late. Thank you so much for joining us, and thanks for joining us the past few days.
Thank
Bye.
you.
You keep up the great work.